let's bring in our guest for this hour to talk about what we're seeing. Trial attorney Trey Gober is with us. Trey, let's first talk about this PowerPoint issue because it can be a bit convoluted. There are oftentimes that juries ask for demonstrative aids and they are told you can't get this information once they are deliberating because a demonstrative aid isn't evidence. It's not admitted. It's just there to help the jury understand something a little bit better. Your thoughts on the state and the defense's position on this particular PowerPoint?
This isn't a unique or abnormal situation for the state to want to summarize voluminous information with a demonstrative like this. However, I think that the prosecution's missing an opportunity here. We as just receivers of information gloss over with PowerPoints. Nobody wants another PowerPoint. This is an opportunity to pull out a pad of paper, a big poster pad of paper, for the prosecutor to get up and stand and write, what are the differences between these statements the defendants, these inconsistent statements the defendants made over time, and you're writing it live, the little summary bullet points. That's a lot more impactful. It's a lot more memorable for the jury. It's an easier way to get around this Rule 106 demonstrative evidence, giving it prior information. Use the PowerPoint during closing, but during live testimony, write it down in front of the jury. They're going to receive it, and they're going to probably want to take their own notes mentally or on paper themselves because you're doing it, you're writing it down for them.
Great analysis, Trey. Let's talk about the witness that's on the stand right now when this subject of the PowerPoint came up, and that's this case detective who started on this case in 2019. So this is a 2007 cold case, Cold Justice. The Oxygen series got involved and lent resources to looking into what happened to Anita Knutson. And I'm wondering what you think about her demeanor on the stand. How's she coming across? Is it authoritative enough because she's going to be the last witness in the state's case in chief?
Yeah, my quick note on her is she's soft. There's some waffling is what I call it, where she kind of goes back and forth. She hedges. Even on the question, will the demonstrative be helpful for the jury? The answer wasn't a definitive yes. It was, well, maybe. Now that's good, and there's a balancing test when we have a witness on the stand. We want them to be credible. We want them to be believable. And if they just go whole cloth with everything that they've been asked by the prosecution, they have no pushback, they're going to lose some credibility points. But at the same time, you got to drive your points home, and the witness is maybe a little soft on that. We'll see how it plays out.
And you got to wonder if she's hedging a bit because the defense, we know during cross, is likely going to be bringing up some issues that have to do with her own personal interactions with police or problematics with an internal report that really don't have anything to do with this case, but the defense certainly wants to bring it up. We could tell that at the beginning of this trial. Trey, stand by. We are getting word that there is a bit of movement inside of the courtroom, so we're going to squeeze in a break and get you back in, hear what the judge has to say about that demonstrative aid and what else the detective is going to testify to on direct. While the jury walks in, let's bring back in trial attorney Trey Gober. Trey, do we call this a moot point? Is that what just happened? We listened to the judge make this ruling, but yet we're not going to see this PowerPoint until the closing argument.
Yeah, exactly what I was talking about. I think that your punchiness with this information, these conflicts, you don't want the jury looking at a stale, cold PowerPoint. You want them paying attention to the witness and understanding the distinction or all the inconsistencies that this defendant has made regarding her alibi and excuses of what happened, when it happened, what she knew, when she knew it. And so getting the jury to pay attention to the witness is key here. This is the state's witness. They need the jury looking at that witness.
Absolutely, and it's the last witness in the case in chief, so this usually means this is one of your most important witnesses that you want this jury to be remembering and thinking about. Let's go back in the courtroom now. Again, Carmen Asham, who is the detective on this case, back on the stand, still under direct examination. We're hitting the pause button on this testimony. Let's bring in trial attorney Trey Gober, who is standing by. Trey, we're getting a bit more information about what the discrepancy was that police found in the statements from Nichole Rice. We mentioned, or the detective mentioned, that screen and bowl. The aunt said that Nichole told her about a cut screen and a bowl, and that she saw the victim's body. Is this enough? I mean, this is really where the case turned.
Ultimately, at the end of the day, the defense argument is, look, you don't have to decide whether our client is innocent or not. You simply need to determine whether there's reasonable doubt. And the reality is that the police, law enforcement had enough doubt that it took them 15 years to act on this case. Even they had doubt. And so any of these discrepancies, the defense will say, look, after this long of a period of time, of course she's going to make some inconsistent statements. Now, it doesn't help that she's giving specific facts like Sprite and chicken strips 15 minutes. That's some very specific information you would think somebody would remember. But at the same time, we're going to see inconsistencies over this period of time because it is so long. And the argument will be she was doing the best she could to give the best information she can. And yeah, after 15 plus years, there's going to be some inconsistent statements. We'll see ultimately how the jury finds it. But at the end of the day, this was a case that certainly law enforcement had doubts on with this particular defendant. That's why they took so long to charge her.
Sounds like a great, compelling closing argument for the defense, Trey, and no doubt we are going to hear a lot on cross-examination when we get there. Please stand by. Thank you for your analysis. We're going to get to a break and pick it up where we're leaving off with the detective on the stand talking about the problems with the statements from the defendant.